In 1993, Craig and Simone Tobin became the guardians of a 4-year-old child. They separated in 1996, and in 1997 the court made orders based on the best interests of the child for Craig to pay child support. Craig appealed on the basis that he was not a parent within the meaning of the Family Law Act. The court really had to consider two questions. First, whether the principle that the best interests of the child are the paramount consideration in parenting matters applied in relation to child support. The second was what is meant by a parent with liability for child support payments. The principle that the best interests of the child are the paramount consideration in parenting matters is found in Section 65(e) of the Family Law Act. But Section 65(b) of that Act says that this division, which would include Section 65(e), does not apply to child maintenance orders. So the best interests of the child are not the paramount concern when it comes to child support proceedings. The second question was more interesting. Under Section 60(c) subsection 1 of the Act, parents had a primary duty to maintain their children. Under Section 60(d), parent included an adoptive parent. Under Section 66(m), sometimes step-parents may have a duty to maintain their stepchildren. Nowhere does it suggest that child maintenance should be paid by a guardian or any other person who stood in loco parentis, or in the position of a parent. On the other hand, it would seem to make sense that if two people agree to care for a child, this commitment should continue even if they separate. The court considered the Family Law Act and also the Child Support Assessment Act and found that in various places they used the term both parents, which suggested there were only two parents. The court said if we were to accept the submissions that child support or child maintenance is payable by someone standing in loco parentis as well as by the natural parents of a child, then the language of the statute would need to be interpreted to include more than two possible parents. In our view, the language of the statute does not enable such an interpretation to be placed upon it. The result was that a guardian who had not adopted a child had no liability to pay child support.